Welcome back. We are now at the third panel. So the third panel is a panel that we were waiting for 2 days, actually, is a panel that will focus on something that is extremely important for us, that is the crucial role of reporting persons, and in particular whistleblowers, in detecting fraudulent practices and corrupt practices in the area of taxation. So this panel is the third panel of day 2, and will be chaired by Mary Inman, that is a renowned lawyer, whistleblower lawyer, partner in Costantino Grasso's London office. So dear Mary, the floor is yours.
Thank you, Costa. It's a pleasure to be here today. I absolutely believe that we saved the best for last, because you can't talk about fighting tax fraud and tax evasion without talking about whistleblowers. It's, as Senator Grassley has said, it's like harvesting corn with a rusty pair of scissors. So we don't want to do that. So I am delighted to be joined today by 3 terrific, knowledgeable panelists on this topic. And before we jump in on that, I just did want to say that this isn't the first time we're hearing about whistleblowers. My law partner, Poppy Alexander, yesterday was talking about the role that whistleblowers play in money laundering and some parallel types of frauds that also capture tax evasion. So we're picking up on a thread that was certainly discussed yesterday, but we're going to dive in a little bit deeper. My area of expertise is in representing whistleblowers around the world under the various government programs that actually pay whistleblowers as confidential informants for that information. I think people are well aware that in the United States, the IRS has a tax whistleblower reward program. In fact, Charles Middleton, who we'll be talking to, is actually one of the whistleblowers who has used that program. But in addition to the IRS program, there are 3 states in the United States, New York State, District of Columbia, and Illinois, that also pay whistleblowers for bringing information about avoidance of their state and district tax obligations. In Europe, HMRC in the UK, Moran may be talking a little bit about this, does have a reward program. It's discretionary, though. It's not mandatory. And that's something we can talk about. And then finally, South Korea, their National Tax Service actually has probably one of the most longest standing programs, 50 years old, where they also pay whistleblowers. And finally, Australia has flirted with the idea. Their previous Labour Party candidate included that as part of his platform. He did not get elected, but now we do have a new Labour candidate as Prime Minister, so maybe we'll get some traction there. So that's just a little bit of background, a sort of a whistle-stop tour of whistleblowers around the world and the various governments that see fit to try and incentivize them to come forward. All right, so let me just introduce the panelists for you and tell you a little bit about how we're going to run this today. Charles Middleton, Moran Harari, and Dr. Salvatore Coluccio are going to be each presenting a 10-minute topic, a discussion on the topic, and then after that we're going to reserve 15 minutes for questions. So please make sure that you put your questions into the Q&A, and we'll make sure that we get to those at the end. And I'm really delighted to note that my colleague Cleve Lawrence has corrected me that the state of Maryland also has just recently adopted a whistleblower program. So that's absolutely right. Thank you, Cleve, for helping correct me right there in real time. Okay, so I will start by introducing the panelists. So Charles Middleton's a former senior tax executive at several Fortune 500 corporations. He has filed allegations against one or more of his former employers for improper practices resulting in the underpayment of taxes. He alleges that he has faced retaliation for filing various tips with the US IRS whistleblower program and has been blacklisted from employment. So we're going to hear from Charlie, who's going to tell us about effective tax whistleblower award programs and how they give corporate tax fraud nowhere to hide. We will next be hearing from Miran Harari. Miran is a tax lawyer who's been working for 12 years in the field of taxation and financial transparency. She's the founder and director of Tax Justice Network Israel. She works at Tax Justice Network in the UK, where she leads research on the Financial Secrecy Index and Corporate Tax Haven Index. Last but not least, Dr. Salvatore Coluccello we'll be talking about whistleblowing and pentitissimo, the role of collaborators in legal and extra-legal governance. Salvatore teaches organized crime and human trafficking at the undergraduate and postgraduate level at Coventry University in the School of Humanities. And he's a course director for the MA in Terrorism, International Crime, and Global Security, and the MA program in Countering Organized Crime. So without further ado, I'm going to turn it over to Charlie first. And Charlie, you've got 10 minutes to discuss your topic of effective tax whistleblower award programs, how they give corporate tax fraud nowhere to hide. Over to you, Charlie. You're on mute. Sorry, Charlie.
Okay. So as Mary mentioned, I was a senior tax executive at a couple of big companies, including Walmart. I filed Form 211s, which is the IRS form where you tell the IRS about a deficiency. After I was fired for raising the issues internally. This happened actually at more than one employer. The lesson that I would take away from my experience is that tax whistleblower programs can be effective. In fact, I would argue that they're probably the most effective way to increase voluntary compliance, but that they have to be designed properly or they won't work. The IRS's program has raised about $6 billion, which sounds like a win. But it's raised $6 billion over 15 years, and the annual tax gap, the annual amount of tax cheating is estimated to be 400 billion plus. So that, if you do the math, is something like 0.06%, a rounding error, right? So the IRS's program is a success on one hand, in that it's raised a lot of money, but it's an abject failure on the other, in that the amount of money that's raised as a fraction of the cheating is an extremely low number. I think that in designing a tax compliance regime, it's important to understand the players' incentives. A company is going to cheat on its taxes if its accountants and lawyers say it's okay, and they've seen everyone else get away with it. So we know why the cheating is happening. We know that the cheating is happening, and we know why it's happening. So why is the IRS not able to stop it? The IRS, constantly claims that they don't have enough budget, but when their budget is $10 billion a year, it's not small. I would argue that $10 million is swamped by taxpayers' resources. Taxpayers have access to law firms, accounting firms, and they pay 2 or 3 or 10 times as much as the government does. They also have this staggering information advantage. They understand their businesses. They have the facts. The IRS auditor has to try to understand the business as well as the very well-educated person on the other side of the table who is feeding them a line that sounds plausible, right? It's only if you're on the inside that you know where the cracks are, where the fraud is. So only by incentivizing tax professionals to come clean about tax fraud does the IRS have a hope of encouraging taxpayers to come into voluntary compliance and catch the cheats. So I would say that that's not only true for the IRS, but it's also true in foreign countries. Some people are offended by the idea that a whistleblower would get paid, but That's the only way that that incentives get created in our capitalist world. Currently, the incentive is very, very strong to go along with the fraud. As a matter of fact, I wish I would have gone along with the fraud, right? I have been underemployed ever since, right? I was a rapidly rising tax executive, and I was instantly derailed by growing a conscience, right? That was a mistake. That was a tactical error. It shouldn't be a staggering error to tell the truth. So I think that the rules ought to change, and tweaking them by saying, oh, well, we'll protect your identity. Nonsense. It can't be done. You have to give strong financial incentives on both sides. You have to have checks and balances. I mean, the US does have a rule that says that the IRS is required to keep whistleblowers' identity confidential. But in my case, the IRS agent who investigated the claim went to work for the taxpayer, right? It's not possible to keep secrets. What you have to do is have strong, well-paid law firms like Mary's who have a strong financial incentive to fight on the side of compliance. So that's my opinion. The specific deficiencies with the IRS's program is they have not paid. They don't pay claims, right? The one biggest claim they've paid went to Bradley Birkenfeld, and he's the only guy who went to jail for the tax fraud that he revealed at UBS. Again, very strong disincentive for a whistleblower to come forward if they see the one guy who goes to jail is the whistleblower, right? Now they did pay him $100 million, so you know it's somewhat of a good story, but you know the fact that the IRS has waited on average 12 years before paying, but the retribution is almost instant, means that tax professionals have an extremely strong disincentive to blowing the whistle. One of the things which should be understood is the role of the big four and the big law firms and the tax planning community. These people, who I include myself in a prior life, are not scofflaws, right? They're not bad criminals. They don't kick the dog, right? They are pillars of their community. We collectively commit what is obviously crimes, right? When you see a business that it's like one of my former employers was very profitable, paid all of its taxes in the US, and then transferred 2 employees to a tax haven and reported all of the income in the tax haven, it's too good to be true, right? Now there were documents, there were piles of paper, transfer pricing studies that all said that it worked. Of course it didn't work. Of course it wasn't driven by business purpose, right? But the IRS audited and it lost because it was fed a line of false statements, right? Did you ever transfer any contracts of value outside the United States? No, we did not. What's the IRS going to do? Raid the place and steal and take the computers and do a forensic audit of the computers? No, they're not, right? But talk to the whistleblower. Hey, you know, you say that they cheated. Show us. The IRS has a tool called 6103N that allows audit teams to talk directly to whistleblowers. It's never been used, ever. It's been around for more than 15 years. It has never been used. So, you know, the lesson for the IRS and for other countries is administer your program properly, and you will change the incentives. And, you know, you'll change the incentives for the employees, the tax professionals, and you'll change the incentives for the company, The company will know if they do this dramatic tax cheating, word's going to get out. One of their employees is going to blow the whistle and get rich, right? And so there'll be nowhere for tax fraud to hide. So voluntary compliance will go up dramatically. I think it's pretty simple and powerful, but there's a very strong lobby against it, right? The corporate lobby will tell you that it doesn't work. It's immoral. It's wrong. You can't pay these people vast amounts of money to rat out their employers. That ain't right. You know, there are no rich whistleblowers. There's one. He went to jail. I mean, tax whistleblowers. It's a myth, right? The corporate lobby story is crap, right? So I think that if you parse the logical conclusion is create checks and balances and create the right incentive for people to do what I did.
Thanks,
19
Charlie.
seconds. Cheers.
Thanks, Charlie. Right on time. I want to turn it over to Moran Harari. I appreciate, Charlie, you having the fortitude to tell us your story, which comes at great risk to yourself. So I hope that folks will have lots of questions for you. Start populating them in the Q&A function, and we'll get to you at the end of the presentations. So Moran, over to you. You're going to talk to us about the role of offshore leaks in combating financial secrecy.
Yeah. Hi, just a minute. I need to share my screen.
We just saw it, Moran, and then it changed. We had your slide just for a second.
Yeah, let me check. Sorry for that. Yeah, can you see? Can you see?
Yes, yes.
We can see, yep, perfect.
Okay. Thank you so much, and Marie, and thanks, Charles, for your presentation. That was really important to hear. My presentation would just a minute. It's not working. Okay. Yeah. So my presentation would not focus on specific whistleblower, but my presentation would focus on what we earn from the high price that those courageous whistleblowers has paid in the past. So in the last decades, as we all know, major leaks have exposed the way that financial institutions and service providers and even authorities have assisted individuals and entities, either directly or indirectly, to evade or avoid tax and launder money. And these leaks have significant role in changing the legal landscape of financial secrecy around the world. I have only 10 minutes, so I chose 3 episodes, like the UBS, Charles, you mentioned that as well, the Lux leaks and the Panama Papers, and I will try to explain what exactly they were, ensure the impact and the remaining issues. So the UBS scandals and the Credit Suisse one. In February 2008, the German tax authorities bought stolen customer account information from an employee in LGT Bank in Liechtenstein and shared the information with countries around the world. The IRS thereafter initiated an informous action against over 100 US taxpayers. And they realized that the scale of tax evasion is way bigger than they thought. Soon after, they investigated the UBS and they disclosed the way the bank helped US taxpayers evade tax through the use of offshore accounts. In 2009, the UBS acknowledged its role in facilitating US tax evasion and agreed to pay $780 million fine and to turn over about 4,700 accounts with US client names. Now, it's important to emphasize, as probably all of you know, that the bank fought really strong back against disclosing more names, not only because they were losing clients and reputation, but also because it was a violation of the Swiss secret banks laws. In 2011, the US started investigating Credit Suisse, which later pleaded guilty in assisting US taxpayers hide their offshore accounts and agreed to pay the US authorities not less than $2.6 billion fine. In terms of impact, the UBS scandal provided the key political justification to the enactment of the Foreign Account Tax Compliance Act, which we know as FATCA. This act requires foreign banks to either disclose their US customer accounts on an automatic and annual basis or pay a 30% tax on their US investment income, which is sanctions banks cannot really afford paying. Now, although the bill was already introduced straight after the UBS in 2009, it has taken several years and it came into effect in 2014. The FATCA has triggered the G20 to push the transparency agenda forward, and soon after the OECD followed suit and created the Common Reporting Standard, as we know, the CRS. Now, as opposed to FATCA, which is a bilateral and asymmetrical agreement of the US with countries, the CRS is a multilateral agreement between countries to automatically exchange bank information. And as of 2022, there are more than 100 jurisdictions that are already exchanging bank information automatically. The other thing is that in 2018, Switzerland has joined the CRS agreement, although issues remain. So additional massive links regarding Swiss banks in recent years reveal that Swiss banks have still been involved in assisting their clients to evade tax and launder money. For example, there was the Swiss leaks, as we know, in 2015. In 2019, the UBS was found guilty of tax evasion by the French court and paid even a higher fine of $4.5 billion. And not long ago, in February 2022, there was a massive leak from Credit Suisse that exposed the hidden wealth of clients involved in torture, money laundering, and other serious crime. The other thing is that bank secrecy laws are still a problem. In fact, Switzerland has taken a giant leap backwards in 2015 in the protection of whistleblowers with legislation that make it even more difficult for an employee to make a disclosure beyond the employer. And it's also important to say that still, if the CRS is a huge progress, but many low-income countries are still excluded from joining it. And the US is still not willing to join the CRS or alternative to make the FATCA more reciprocal. The LuxLeaks scandal. So in 2012, it was the investigative journalist Edward Perrin exposed the existence of confidential tax rulings in Luxembourg based on documents that were leaked to him by Raphael Hallett and Anton Dantour. In 2014, he collaborated with the ICIJ, and then they published the LuxLeaks investigation. That investigation revealed how nearly 340 multinationals have reduced their tax bills by making sweetheart deals with the Luxembourg governments. The revelations included some of the world's largest companies like Disney and Skype, and some of which ended up with less than even 100% tax. In terms of impact, following the leaks, the European Parliament decided to set up a special committee to look into the compatibility of tax rulings and clarify how to interpret and apply national tax legislation with state aid rules. And as a result of that, in December 2015, the EU Directive on Administrative Cooperation, as we know as DAC, was amended to oblige mandatory automatic exchange of information in relation to tax ruling. So member states, the EU member states, had to transpose their directive by end of 2016, and they are doing it. And the other thing is that in recent years, the EU has carried many state aid investigations regarding the consequences of confidential tax ruling around Europe, some of which were successful and some of which are still ongoing. But issues remain. So multinational and authorities still abuse loopholes in the tax ruling practice to circumvent transparency regulation. For example, just last year in 2021, there was the Lux letters investigation, and that exposed unwritten mechanisms in Luxembourg, which aim to circumvent the obligation to exchange tax rulings automatically. The investigation was carried out by several journalists from Le Monde and Süddeutsche Zeitung and more, in collaboration with us, the Tax Justice Network. And the other thing is that although more tax rulings are now available online, most of the tax authorities still publish only a selection of the rulings and not all of them. So we don't really know which one they choose not to put online. And the vast majority of them are just summaries, from which is really difficult to grasp the actual tax rate that was agreed. The Panama Papers. In April 2016, the ICAJ published the results of more than 1 year investigation. They examined over 11.5 million secret documents from the Mossack Fonseca, the Panamanian law office. And the files expose a worldwide web of offshore shell companies that the company set up for a long list of clients. It was a massive leak. It included more than 2014 offshore entities connected to people in more than 200 countries and territories, and about 140 politicians and public officials were revealed to hold offshore accounts, including the prime ministers of Iceland, the president of Ukraine, and the king of Saudi Arabia. In terms of impact, the Panama Papers has become a global touchstone of the debate around corruption and financial crime and inequality. The impact was enormous in many respects, including governments recouping more than $1.3 billion in back taxes and penalties. In terms of the change in the financial secrecy landscape, the EU immediately set up the PANA committee, who investigated many of the relevant cases, and as part of its recommendation called on the EU Commission to provide stronger protection for whistleblowers and to set up public registries of beneficial owner of legal vehicles like companies and trusts. Soon after, the EU has amended its AMLD directive to require that, and several years now, we EU member states are obliged to manage public registries of beneficial ownership. Ghana's Registrar General said that the Panama Papers was instrumental in his government passing their beneficial ownership registration law, and it's definitely, I can say, one of the most progressive beneficial ownership law in the world. In the US, the Panama Paper helped persuade the Congress to pass the Corporate Transparency Act, which became a law not long ago in January, and which requires beneficial ownership registration of US companies. And to date, there are more than, according to our research, there are more than 94 countries that have beneficial ownership legislation. But issues remain. So most of the beneficial ownership registries that exist are still not publicly available, and some of the beneficial ownership laws have creative loopholes, or they have very, very loose triggers for registration. And the several offshore leaks that followed Panama Papers in recent years, and I'm sure many of us know them, the Pandora Papers, the Mauritius leaks, there are so many, they prove that there is still a lot to be done to combat financial secrecy. Maybe just one more thing that I can say is that we at the Tax Justice Network and other organizations like us have been advocating for these changes for years. So to give you just an example, our financial secrecy index, which we launched in 2009, for several editions, the countries that we assessed received the full secrecy score of the indicators that include beneficial ownership and automatic information exchange, simply because there was no country to do that. That has changed more or less around 2015, but there is no doubt that we would not have this progress in the public debate and international law without these links. Thank you.
Thank you so much, Moran. It's a great transition to go from Charlie talking about whistleblower insiders to you talking about leakers. It's another form of whistleblower. And I think what's so interesting, of course, is that none of us know who within Mossack Fonseca in the Panama Papers leaked that information. So it sort of ties nicely to Charlie's point, which is that it's important that your identity be protected. So yes, I think, again, we have whistleblowers in the form of leakers to thank for exposing this information that allowed this legislative and other change to take place. I want to turn things over to Dr. Salvatore Colicello. And before I do that, I want to remind people the Q&A function is open, so please don't be shy about putting your questions in. Salvatore, I'm going to try and do my best Italian to introduce your topic, which is whistleblowing and pentatismo, the role of collaborators in legal and extra-legal governance. Over to you.
Thank you. Thank you. I'm sorry. I hope that my connection is good. At the moment, I'm in Palermo with 40 degrees and 30 students on a study trip. So it's been quite, an adventure to be here now today.
You sound just fine. None of those unruly students, we can't hear them in the background. You're totally fine.
Okay, that's good. That's good. So yeah, thanks again. Thanks for the invitation. And the two previous papers were great. I don't know if mine actually, it's actually probably a bit tangential to what is going to be discussed today. But I have an interest in organized crime. Obviously, comes from my background as well. I'm Italian, as you can hear from my accent, and I've been researching the mafias and the mafia consortia in general for a number of years, and I was actually quite fascinated by these pentiti. The mafia pentiti are sort of super grasses, turncoats. In Italian, we use pentiti as in a way they repent from actually what they did within the mafia organization. So yeah, I'd like actually to draw a sort of a comparison between the whistleblowers and the pentiti, and of course they operate within two different milieus. The pentiti are in legal governance, and the mafia, it is actually quintessentially, an extra legal governance. So I don't think I have control of my slides. So is it possible to have next slide? Okay, yes. So, my interest on this topic actually came a bit, I don't know, some times ago, because I don't know if you're familiar with this movie. It was quite successful in Europe. It's a movie that was released in the early 2020s, and in the UK in the summer of 2020. And I was, as I said, fascinated by the title of the Times. They reviewed the movie, and they titled, The Traitor, The Godfather, and Mafia Whistleblowers. This was is the story is based on the story of Tommaso Buscetta. Is the so-called boss of the two worlds, and certainly the most important mafia informant in Italy in the 1980s. He was actually the person who first, the repentant, the mafia collaborator, who first handed over the keys to approaching the mafia organizations, and thus changing the fate of the relations between the state and an organized crime in Italy. The next one, please. So I mean, was Tommaso Boscetta a mafia whistleblower? And can we use actually the term to describe a significant and important mafia collaborator, actually a whistleblower? So, we know that that whistleblowing has been one of the most critical tools in uncovering, identifying, and prosecuting tax crime and corruption. But we also know that they cover also important reporting on various on a variety of misconducts, illegal acts, harassment, wrongdoing, and also the risks to persons' lives, health, and the environment. However, they operate within a legal governance. We also know that there is not a universally accepted definition of the term whistleblowing, and it is not easy to translate into other languages, like Italian, for example. Though in Italian, in the last probably 10 years, 12 years, the media have started using this word, and for this reason, the Article 33 of the UNCAC, the United Convention Against Corruption, does not use the term whistleblower, but instead it uses the term reporting person. At the same time, over the past decades, several far-reaching corruption scandals all over the world have actually involved policymakers at the highest reaches of government, staggering amounts of bribes and money laundering of epic proportions, as we know from a number of reports. In the wake of scandals, awareness has grown about the contribution of extra-legal governance organizations in governing political corruption, that is, those organizations that are performing crucial functions as enablers, brokers, guarantors, and enforcer of corrupt deals. Next one, please. Mafia-like groups, as I mentioned before, actually are quintessentially example of extra governance, extra-legal, governance organizations. Given their ability to establish extra-legal governance both within and outside their organizations, and the mafia actually are best explained as political organizations that exert control over a territory where there are forms of governance. Members of these organizations typically share the same norms, rituals, and code of conduct. Next one, please. So the link between the mafia and politics is a real partner. It's not actually a real partnership, but rather part of a web of corruption and clientelism, which is actually unfortunately still widespread in Italy. Actually, there is no distinction there between north and south. The web enables collusion to flourish. Mafia uses political corruption in a relationship with equals, politicians, public administrators, bureaucrats, but as a clientelistic approach to civil society, a sort of vertical dyadic relationship. Even historically, between local society and politics, it was the mafioso who did the mediating between the mafia and institutions. Who did the mediating between mafioso and the institution? This was the job of the politician. Next slide, please. The pentito, Antonio Calderone, in his book interview with the sociologist Pino Arlacchi, actually the next one again, compared the mafioso to a spider as he builds his web of friends, acquaintances, obligations. Like spiders, the mafioso have spun an ensnaring web. They've rendered a segment of a society contiguous to, if not complicitous, in their affairs. So now, among the most traditional and rigid orders of the mafia organizations, of the mafia association, there is that of omertà. Next one, please. You know, the silence has always been the most obsessively imposed, emphasized, and protected, you know, within the organization, because it actually can ensure more than others alone, and over time, the stable and last resistance of the pactum sceleris, the crime agreement among affiliates. For the members in this context, the omertà represents a rule that guarantees the same survival and the personal power of the top bodies of mafia organizations. So the study of the behavior of the mafia affiliates and their relationship with the world. Actually, I think there are a couple of slides as well. Sorry, I was not looking. Yes. So yes, a bit. Yeah. Okay. Yes. So this is actually a good example. These are some good examples of the affiliation with the mafia. Now, from the moment of this combinazione, the man of honor progressively becomes aware of having lost a meaningful part of his autonomy and individuality. He no longer belongs to himself because he now belongs to Cosa Nostra. He's an integrating part of a system that organizes his life. So, as I was saying before, the study of the behavior of the mafia affiliates and their relationship with the world, with the possession and transmission of information becomes significant, since the control of the visibility and the resulting monopoly of invisibility are among the main tools that ensure and guarantee power. The next one, please. Does the worst betrayal is actually not these that normally we find it in feuds between families, in cross vendettas, in the killings between winners and losers, or in the killing of those who were formerly friends and allies. But it's actually the infame, the villain, the traditore, the traitor, tragediatore, as they say in Sicilian, the liar, the one who speaks, the one who violates the rule of solidarity and complicity, silence, omertà, letting emerge what usually disappears in the unspoken. I mean, I'd like to draw a quick conclusion here is the next one. So, this association from a group where cooptation is for life, whose membership is sanctioned by a blood ritual, whose exit can only take place with blood, is dissipated precisely through the world. So, it's this is the word of the mafiosos saying, and I mean, we can probably extend this to the whistleblower, or by the people connected to him, that they require particular attention, because often the breaking omertà, the exit from silence represents the symbol of a malaise, of a fracture, which inevitably involves a criminal organization, or in some other cases, any other organization, of a conflict, of a possible process of change, which we all hope for. Thank you. I hope I was not very fast. I hope that I actually did it within 10 minutes. And thank you.
You're just fine. Thank you so much, Salvatore. So we have about 7 minutes left for questions. I want to turn it over first to Professor Grasso, who I know has his hand up. I also encourage the panelists to ask questions of each other. But first, over to you, Costa.
Thank you very much, Mary. And I don't want to abuse of my position, but I think that it's a very interesting panel, this one, and it's very important for our research, actually. So what I would like to ask you is to try to reason a bit all together from something that I said Charlie, but I would like to open this also to the other panelists. Say, why not Mary? Because of her incredible expertise. And it's about, we've looked at the panel one about the situation of state capture and situation of political capture. And then Charlie said, of course, that we are facing reluctance from regulatory authorities and from governments to adopt effective protection for whistleblowers, even more awarding system. And then he also said that at the same time, corporation and elite and the corporate power try to lobby against this kind of protection. So my question will be, easily said, why? And what are the, for you, the deep reasons that are there that let this elitist and powerful group to be so pushing against the protection of whistleblowers? Is this something related to the disruptive thing that they can alter the status quo? And when I speak about the status quo, is the regulatory capture in which we are? So is this something that they're created that don't want to be dismantled? So what is your point? This is very important to us to understand these, deep reasons, the roots of the problem.
Charlie, I'll let you go first. You're on mute.
I think that the reasons that the corporate community and the advisor community and the politicians who have been influenced with campaign contributions and otherwise to support the corporate community and the advisor community, the reason that population is so anti-whistleblower is that whistleblowers are so effective, right? If you look at any scandal, I mean every single one, there's a whistleblower, right? The auditors don't disclose the problems. There's studies that show that the percentage of time that there's a problem that's revealed by an auditor is less than 5%. Management doesn't disclose it. It has to. The regulators don't. So the whistleblowers are so unpopular because they're so effective. This the same reason why there's regulatory capture, right? Why does industry send? Why does industry reward people who go to the government and then come back to industry? Because it's so effective, right? Why do people spend huge amounts of money to lobby? Because it's so effective. I mean, if you give money to a politician, then he votes your way and there's no more whistleblowers, that's a very effective investment in a low tax rate. I mean, it increases corruption, makes the world a worse place, but that's for someone else to worry about. I mean, I think it's critical that you look at it from each individual actor's vantage and what's in their best interest. That's what they're going to do.
I agree, and Costa, I would add in terms of just looking at the American model in particular, I'm not so sure that the IRS is so much about regulatory capture as it is about hostility to the idea of sharing information with whistleblowers and whistleblower lawyers. So if you look at the SEC program, which has been so incredibly successful, and you contrast it with the IRS program, which, as Charlie laid out at the outset, has really been underwhelming in its potential, I think it has more to do with the fact that the IRS doesn't have significant budget and resource dedicated to it, but more importantly, it doesn't have the will that the SEC does for seeing the power of the tool and maximizing it. And the other point I'd like to raise is that we haven't discussed this yet, and I think it's really important, and Moran touched upon it, is that we do now have a sea change in Europe with the EU whistleblowing directive, and that came out of Antoine Deltour in the LuxLeaks scenario. It was specifically because of how he, as a French national, was working in Luxembourg and would have been, was prosecuted in Luxembourg for his whistleblowing, whereas he would have been protected in France, his country. So it's, it's a good start. So I don't want to be all gloom and doom. I feel like we have made advancements, but I'd be interested to hear what Moran and Salvatore have to say.
Thanks both. I definitely agree with both of you, and the motivation is money for everything. So it's for corporation. It's definitely beneficial to do the lobby and to do and to push against. It's not this. Switzerland has been pushing so many years for changing its secret laws and protecting whistleblowers, just because this is what the country lives on for many years. So it's been a really influential, all the results. As I try to bring some examples. Some of them were whistleblowers like the LuxLeaks, as you know. The UBS was one as well, and also the UBS, the 2019 case was another whistleblower, Stephanie Gaybird, and that was also, but it's really because they can make such an impact, then the lobby against them is so strong. Then I think unfortunately only cases like this could and did drive the legislation changes that can protect them, and there have been.
Thanks, Moran. I appreciate that. I think we're actually at time. The last question that I just saw come in is whistleblower protection in Italy. I know enough to be dangerous in this regard, which is that even before the EU directive, Italy did have a whistleblower program protection law come into place, but they have not since amended it to get it to be where it needs to be for the EU directive. So they are playing a little bit of catch up, but they were one of the few, believe it or not, countries. I think there were only 7 or 8 countries before the directive that actually had whistleblower protection laws. So Cosa Nostra aside, we certainly need safe houses for whistleblowers for that in particular, but that's more of a practical resolution. But I did want to at least touch on that one question. So Costa, I think we're at time, so I wanted to turn it back over to you. But before doing that, thank Charlie, Moran, and Salvatore, who's left us all, for their excellent presentations. Thank you.
Thank you.
So thank you very much, Mary, for chairing the panel. Thank you, Moran, Charlie, and Salvatore. And so I can now pause the recording, and we will have a break of 7 minutes now.